Pleasure to welcome back to the program Astra Taylor. She's the co-founder of the Debt Collective, author of her most recent book, Remake the World: Essays, Reflections, and Rebellions. Astra, welcome back.
Thanks for having me.
All right, so today, maybe it was yesterday, I guess, the Biden administration announced that they are going to extend the existing, I guess, under the auspices of COVID, moratorium on student loan debt repayment for everybody until at least, I guess it would end in June, and then 60 days later of 2023, payments would come in. That is supposed to be timed until after the Supreme Court can address the appeal from the administration on two different court cases. Just walk us through briefly those two different court cases, and then, the claims that are made in those court cases, the problem with those court cases, and then we'll talk about the question of the authority under which the Biden administration has issued the debt forgiveness, $10,000 for each student, or I should say borrower, $20,000 if you had a Pell Grant.
Yes. So I think first we want to parse the announcement from yesterday because it is contingent on multiple factors. And that is actually an unusual thing for the federal government to do, to say contingent on action from the court. So the premise is student debt payments will be turned back on 60 days after three things, one of three things. The Supreme Court rules, or debt is canceled, or June 30th. And whatever comes sooner, the payments will turn on 60 days after that. Okay. In my opinion, it should have been whatever happens the latest. Let people plan, or just give a firm date. Because again, what's so hard for these, for the millions of debtors out there is, planning your life and knowing how much money is coming in and having that long-term ability to manage your manage your own household budget. So, what is very important about this, though, is that 60 days after the Supreme Court rules means that those are 60 days where payments are paused, where the Biden administration could use one of the other legal authorities that has to cancel student debt. Right now, these cases that you mentioned are focused on the current plan from the administration, which was based on one authority. Again, there are many. The Department of Education cancels student debt all the time through various programs and through various legal bases. This is not unusual. This is not a radical act. They're taking issue with the specific authority that the Biden administration invoked for this, which is called the HEROES Authority. It's from 2003. And essentially it says the Department of Education has the ability in periods of crises, in national emergencies, a la COVID, to relieve student debt burdens for people. So it is this specific pandemic-connected authority that is in question. It is important to understand that this legal authority is clear. What the Biden administration did is absolutely legal. And I want to take a moment to savor how ridiculous and offensive these lawsuits are. So the one that is specifically spurring them to appeal to the Supreme Court, hardly a place that should be having the final word on this issue. This is the Supreme Court that has recently attacked bodily autonomy and rolled back abortion rights, is trashing the EPA and our ability to regulate the environment, right? It should not have the last word. But the case that is causing them to seek their judgment was instigated by 6 Republican-led states who basically said that a student loan servicer, a company called Mohila, which is based in Missouri, Mohila stands for Missouri, blah, blah, blah. It's a loan servicer based in Missouri, will lose revenue under the Biden administration's plan, right? The profits of this company will be harmed by canceling debt for borrowers. Representative Cori Bush, who is from Missouri, wrote a letter to Mohila clarifying their position, and they sent a formal letter back saying, we have nothing to do with this litigation. This is not true. This is so essentially, pulling the rug out of from under this bogus legal argument. Nevertheless, the case is going. And so it's also important to say that a lower court dismissed this case for lack of standing, saying, look, this is ridiculous. This isn't a real case. Nobody is actually being harmed by student debt cancellation. It was appealed up to the Eighth Circuit, where there were 3 Republican judges, 2 appointed by Trump, 1 appointed by George W. Bush. So this case is ridiculous and should be dismissed. Another major piece of litigation out of Texas, which vacated the program, is equally offensive. Again, a Trump-appointed judge, very ideological. And this is the case teed up right with the Fifth Circuit, which is called, Elizabeth Warren called it the go-to court for conservative lawyers. And this case is brought about by a group calling themselves the Job Creators Network. It's actually a billionaire-backed front group that pretends to speak for small businesses. Guess who the main funder is? Bernard Marcus, the co-founder of Home Depot, who's a right-wing oligarch. It's also funded by Mercer Foundation family money, right? The Mercer family. Claiming to speak for small businesses, they found 2 eager plaintiffs who the argument they're giving is one of them's only eligible for $10,000 of relief. One of them has FFEL loans and so isn't eligible for cancellation under this program. They're saying, well, we're not getting the full benefits of this cancellation, so we want to sue to block it for everybody. And they have succeeded. So they're saying we're being harmed because we didn't get enough debt cancellation. Therefore, we will partner with these reactionary billionaires, kill the program, and tee it up again with that Fifth Circuit, who we know will probably do more damage. So that's why these are so bunk and why we need to explore their options.
All right, let me, and just one thing I'm unclear on, in the first case, right? I mean, there's a real question of standing there, particularly when the supposed these attorney generals are supposedly representing the interests of a company that has in no way made any claim anyways. So there's a real question of standing there. In the second case, I mean, maybe the standing is arguable, but none of these cases, it seems to me, have questioned the authority. It seems like that the judge in Texas basically took upon himself to question the authority, as opposed to addressing what the plaintiffs are arguing, which is that we're not getting enough relief. Instead, the judge took it upon himself to unilaterally decide, well, I'm going to go beyond the scope of what the question is before me and ask whether the statute authorizes any of this anyways, never mind whether it's been applied properly. And he's gone past and I think this audience is somewhat familiar with the demise of the Chevron doctrine, which says that the court, and we're not quite there yet, but that courts usually defer when you have an ambiguity in a statute. The HEROES Act says, if you're in some way impacted by an emergency, then the Department of Education has the ability to relieve some of this debt. To the extent that, how much of an emergency it needs to be. I mean, 9/11 happened in a half a day. The implications may have resonated, and that's why the HEROES Act existed. COVID happened, depending on how you want to measure it, months, maybe years, and how you want to measure what the impact is. I mean, there's a certain amount of vagueness. The Chevron doctrine usually allows agencies to deal with that. This guy in Texas decided to use the major questions doctrine, made up doctrine, didn't exist 10 years ago or 11 years ago, literally didn't, made up from whole cloth. He decides to apply that to a question that wasn't even raised, it seems to me. But be that as it may, that's where we're at this point. And the DOJ is asking the Supreme Court to address this on what grounds? What argument are they basically saying the Eighth Circuit, there's no standing, and in Texas, how are they attacking these claims?
Yeah, I think that they are going to go hard against the question of standing in the case that involved Mohila, the loan servicer. And again, the lower court was very clear about this, and dismissed it outright for that reason, and saying, look, there's no basis for harm for having that legal standing to bring this case. In Texas, the judge said, some paradoxical things. So one complaint from these plaintiffs was not just that we didn't get enough debt relief, but it's also that we were denied the ability to participate in a period where we would be able to comment, right? And this HEROES Act, this emergency provision, does not require any notice and comment period, right? So they're complaining about something that this rule explicitly doesn't require. And in the judge's very brief opinion, he kind of contradicts himself and acknowledges that. He's like, well, they didn't get to have this, the chance to comment on the laws, and it's also, but also it doesn't require that. And so it's quite a bizarre argument, which is why legal experts have said this is a logical pretzel. This is judicial overreach. And this person is essentially trying to litigate, create law, to legislate from the bench, which is incredibly alarming. And so this is why, I think we do have to put this whole fiasco, in the perspective of the right-wing takeover of the courts over the last 40 odd decades, probably longer than that, and really ask what this means for progressive movements writ large, because it ultimately is about so much more than student debt cancellation. And, it's very important to say, this is, actually, we cannot just all roll over based on whatever the Supreme Court decides in the society anymore, especially again, when there are all of these other legal avenues available. We're talking about something very, very mundane. We are talking about student debt cancellations. What will this mean for bigger fights ahead?
Well, do you have optimism at all, given Amy Coney Barrett's reluctance to hear those first two cases where she just essentially shot them down? I mean, it seemed maybe I'm looking for silver linings where there are none, but what's the sense of maybe the court's posture towards this?
Yeah, I don't know. I'm definitely, not privy to any of the rationale that went into her refusing to see two previous lawsuits. It could have been that she was holding out for something that, in her mind was more credible. I do think, one thing that has been raised is that the conservative courts might not want to assent to these cases simply because they create such an open platform for standing. And it has been actually conservative legal scholars who for decades have said, no, unless you have personally, lost, a significant amount of revenue from, an environmental disaster or, a car accident or something, you don't have legal standing. Sorry. So these people, they cannot prove any monetary damages. They really have no basis for suing. And, it is actually, the conservative legal world that has been pushing to restrict standing. So it could be, that in some sort of twisted sense of their own sort of broader ideological self-interest, that they don't want to deal with these cases, not because they're on our side or because of any sense of justice.
That's a fascinating point. I should just say, we cover a lot of tort cases. And one of the themes that have been happening over the past 10, 15, 20 years really is the Supreme Court basically shutting the door to the courthouse to a lot of claims across the board, saying you don't have standing here, so that you can't bring suits against government agencies, but also more primarily like even corporations. So that's the situation. We have no way of predicting. If I had to guess, based upon what I know of this court, they're going to find anything that they want to shoot it down. It's basically they start with the policy outcome, and then they reverse engineer it, as this judge in Texas did.